Guys, Nnamdi Kanu was in court today, maintaining his ground that he has not even been told the crime he committed. He was expected to open his defense, but he continued telling the judge to tell him his crime on the basis of the Constitution of Nigeria. Don't forget that Nnamdi Kanu has equally argued that the court in Nigeria has no right to try this case. He has also told Justice Anyoko that she is not supposed to be part and parcel of those who are to try or to handle this case because she has been excused. Now, Nnamdi Kanu is saying they've not even told him his crime and they want him to open defense. He insisted in a defiant move that shocked the judges, insisting that they should first of all tell him his crime. Don't ask me to open my case without me even knowing what you are trying me for. And that was how the judge almost ruled, because they said if Nnamdi Kanu is not opening his case, it means he is going to be a kind of, the ruling will take place. The judge can decide to jail him, can decide any kind of ruling, to state any kind of ruling. But Nnamdi Kanu was very defiant. And one of the judges there now said they are going to give him time from now till on the 7th of November. He's still going to appear in court. And that will be the last chance for him. If he fails to open his case, that judgment is going to be passed on him. So guys, but the mood Nnamdi Kanu was in today's court session does not show he is ready to yield to what they are saying. Nnamdi Kanu is maintaining his ground that they should tell him the crime for which they want him to open his case, which is, okay, tell me what you say I committed. Did I steal? Did I buy somebody? What is the crime? Because you know, all of those things that they've been charging him for, gradually they've been like wiping off all those things, and Nnamdi Kanu want them to like say, okay, this is what we want to charge you on, open your case. Nnamdi Kanu wants to know exactly what the charges are, which is what he's insisting, that until he's told his charges, that he is not going to open the case. Now, before we take a look at the video, I want you to just take a look at this reaction. Showore has come out to say that there's already plots by the federal government to jail Nnamdi Kanu. So that is it. And the method they are using now shows that they've already concluded to jail Nnamdi Kanu. I'm just going to read it exactly the way Showore posted it on the Twitter space. Now, this is what Showore said. For the avoidance of doubt and to allow the public, it has become clear that secret decisions have been reached within the Tinubu's regime concerning the fate of Nnamdi Kanu. The plan devised through a high-level political conspiracy is either sentence him to death or condemn him to life imprisonment. This outcome, predetermined far in advance, is now being dressed up in the guise of judicial procedure. So Showore is saying that they've already concluded that it's either life imprisonment or sentence to death. Can you imagine? Now, Justice Omotosho is expected to conclude Nnamdi Kanu's trial by declaring that he refused to open his defense, amount to admission of guilt, a convenient interpretation designed to seal a verdict already agreed upon behind closed doors. The ruling is anticipated this November. So Showore is saying that they've already concluded, and they just want to present it in a way that if Nnamdi Kanu insists that he wants to know his crime, they will just rule that he has refused to open his case, and on that basis the judge can rule anything, either life imprisonment or death sentence. Now, I'm just going to allow you to take a look at this video on updates. Just take your time, watch these videos, and let me know your thoughts in the comment section below. Now, take a look.
Lord has adjourned the matter to 7th of July, 7th of November, for the Mazi to open his defense, or he will foreclose his right of defense. So we are going back to the drawing board, go back to office, look at it, and offer our advice as consultants. But having said that, the issue of talking to the press also came up, and we said no. Right to address the press is a fundamental right, because once we fail to address the press and tell the press the real position of things, they may go about report, especially those of them who don't have the opportunity of coming inside the court. They may go and report another thing. So the court say that we have a right to exercise to address the press, which even the prosecution has confirmed. But he said that we should do it in line with the law, just like as I'm doing it now. I just reported what happened in court, not prejudicing what is happening, what is going to happen. And I believe that just like every other person, we are calling Mr. President to discontinue this trial. It's embarrassing Nigeria.
Ladies and gentlemen of the media, we have concluded today's hearing in the case of Nnamdi Kanu, and the crowning glory of it was that he put up a very good defense of himself, even though he was concentrating on the objections raised to the jurisdiction of the court. On that note, the court adjourned for further hearing to 7th of November, when the court expects that he will enter his full defense. Well, having said that, I know a lot of people have raised questions and eyebrows about the propriety of Nnamdi Kanu representing himself. It is his decision to make. He has the right under the Constitution to defend himself, and this case being politically charged, I think the idea or the notion that this is a normal criminal case has to be dispensed with. This is a normal criminal case at all. If you want to understand the complexity of this case and the true political dimensions to it, you think of the case of Nelson Mandela, Martin Luther King, or Bafemi Awolowo, Mahatma Gandhi. These cases were all politically tinged cases masquerading as criminal prosecutions. And these great men I mentioned, at some point in their struggle, at some point in their travail imposed on them by the state, they took the podium and defended themselves. So a politically charged case often comes with some unusual dimensions like this. So because, why? The reason is simple. Lawyers are restricted to very narrow wiggle room when they are doing a case. And that narrow wiggle room can be inimical, can be prejudicial to the interest of the client when the case has a political dimension to it. That thing needs to be out there. That limitation we have is not expected of the defendant himself. So a lot of times the defendant himself will make the best defense of his case at that very point in time. That does not obviate the fact that the presence of a lawyer in a case is always better. But in certain circumstances, there are exceptions, and the exception is, this one is one of the major exceptions. Thank you.
Thank you very much.
Thank you very much.
Okay, my Lord has adjourned the matter to 7th of July, 7th of November, for the Mazi to open his defense, or he will foreclose his right of defense. So we are going back to the drawing board, go back to office, look at it, and offer our advice as consultants. But having said that, the issue of talking to the press also came up, and we said no. Right to address the press is a fundamental right, because once we fail to address the press and tell the press the real position of things, they may go about report, especially those of them who don't have the opportunity of coming inside the court. They may go and report another thing. So the court said that we have a right to exercise to address the press, which even the prosecution has confirmed. But he said that we should do it in line with the law, just like as I'm doing it now. I just reported what happened in court, not prejudicing what is happening, what is going to happen. And I believe that just like every other person, we are calling Mr. President to.
We understand that you are no longer in Kanu's limit.
No.
So
we remain as consultants to him,
okay,
and as his brothers, and braves in council.
okay, based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very very disappointing. There's a thesis that has become intractable because Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that.
It's good for us to put the record straight. Nnamdi Kanu is not saying that he will not enter defense. Nnamdi Kanu said, under what law are you charging me? Going by the Constitution, there is no charge against him. That tell me the law, that the court should tell him the law upon which he's been tried. Now, my Lord is on his own saying that whatever thing that you have to say should be ruled at the final written address, and it should be upon a conviction to know whether you are supposed to be convicted or not. And Nnamdi Kanu said no. There are thresholds, there are hurdles upon which you need to cross for you to reach at that particular issue. And one fundamental issue there is that my Lord said, we are talking about issue of extraordinary rendition, the way you have been brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion Nnamdi Kanu filed, Nnamdi Kanu said, Federal High Court has given a judgment in respect of that, and also awarded 500 million naira against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Nnamdi Kanu made reference of the motion in the court file. Yes. And under the Evidence Act, Nnamdi Kanu is saying that under the law, court is under obligation to take judicial notice of every document in your file. Yes. So asking him now to go and enter into a defense and start giving evidence on that is a waste of time. Yes. That court is on its own supposed to take to raise this issue. Yeah. Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Nnamdi Kanu filed a motion, and I think that motion, Nnamdi Kanu said that motion should be heard, and all this issue I raised should be trashed for me to go into trial. So, and into defense. So my Lord, Nnamdi Kanu maintain his position on that. So my Lord said that he has joined to tomorrow for him to enter defense. Just like we said, we are no longer into the matter, but we are still he's still consulting us. I am saying so. On handling his matter in court, he felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice, just to get the record straight, so that people will not say that Nnamdi Kanu refused to enter defense. No, there is no such issue. Nnamdi Kanu said, address me on this issue. Okay. That is the position.
The honorable member here.
My name is Right Honorable Obi Akocha. I represent the great people of Ikuano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
My colleague here would like to...
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist, and particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England, where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. The Honorable, did people make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Mazi Nnamdi Kanu is completely right and within Section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law that is not existing. Wonderful. Thank you.
Thank you very much.
As you can see the way I dressed, Mazi Nnamdi Kanu, for the purpose of this trial, is representing himself in this matter. So, and on this particular issue, we are now acting as his consultants. I'm not the only one. He has many consultants, both foreign and local, whom he consults on this particular issue, not representing him here. Now, if you recall, Mazi Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So, in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So ordinarily, the court is expected to to raise this issue and ask the parties to address him on this issue, whether the law does exist. So now Mazi Nnamdi Kanu has raised the issue and said that I cannot enter defense because in a criminal jurisprudence we have a procedure. The procedure is that for you to even assume jurisdiction, there must be a law. For the law to even exist, for you to rely on that law, the law must be an existing law. And Mazi Nnamdi Kanu now on his own filed a motion on this particular issue, telling my lord that the law upon which I'm being tried does not exist, in line with Section 36 sub 12 of the Constitution. But my lord on his own, just like what we said, my lord on his own said that section is talking about conviction. And Mazi Nnamdi Kanu said, no, you can't be talking about conviction without trial. The trial will lead to conviction. So for you to even talk about conviction, you must first of all address all those issues that will lead to conviction. So that is why we are here. It's not as if that you don't want to enter defense, but he's saying, tell me the law upon which I'm being charged and tried.
But why are we here at this stage, knowing that at the point he once pleaded not guilty, and then the witnesses from the prosecution were examined and cross-examined?
If you say that you are not taking plea, then how will you tell the judge to discharge and acquit you for no trial, because you first of all you first of all plead guilty. Are you them saying you first of all plead guilty for court to have jurisdiction for you to even make an application? If you do not plead guilty, there is nothing before the court. So that was the issue. And he's now saying that if the law, the charges upon which I pleaded guilty, does not exist. We are talking about law.
Yeah, what about the trial? There was a trial.
The defense opening their case.
The prosecution.
You can raise it. The law said that you can raise all this issue at any stage.
Okay.
Before judgment. You can raise it at any stage. Either before prosecution open his case, upon prosecution closing his case, or at any stage. So that's the stage Nnamdi Kanu is. So on our own, so we believe that the court will first of all hear this particular motion. I hear them saying, but just like the court said, the court has every right to take decision one way or the other. Then Nnamdi Kanu still have opportunity of going on appeal.
Thank you very much.
So guys, the trial of Nnamdi Kanu is going to make a lot of revelation in Nigeria, especially at this time when we are talking about the menace of the Fulani headsmen, terrorists, terror groups in Nigeria. I'm just wondering on what basis and with what boldness are they going to be charging Nnamdi Kanu? Sure, Nigeria is going to erupt. Nigeria will erupt if the federal government dares, sentence Nnamdi Kanu either to jail or to even life sentence like Shawara is talking. Because on what ground? This is somebody who is asking for secession. What's his crime? And that's why he's trying to know. He's asking them, what's my crime? Why am I in court? Tell me. You want me to open defense of a crime I don't even know what I did? Tell me. You came to Kenya, brought me back to Nigeria, and now you are trying to make me open a case that I don't even know what my crimes are. Recently, many Nigerians fell in love with Nnamdi Kanu, knowing that some of the things we are experiencing today or that are happening today in Nigeria are things he said even before they happened. Sometimes you just begin to wonder the kind of prophetic gift that this man has. A country that has opened the door wide. Look at how Gumi is coming out to speak. Now, there's one headline on the social media where one barrister is saying that the way Gumi is coming out to speak for these bandits and nobody is even bothered about calling Gumi to order. It shows that the federal government has a hand in this terrorism. This man comes out, makes statements that no ordinary Nigerian can make. Speaking on behalf of terrorists, telling you that it's because they were not giving schools, they were not giving houses and all that. That's why they are doing their menace. Is there any reason for which one would pick gun and begin to gun down another person? Now, the federal government is saying that it is a crime for you to associate with anybody, any group that has been designated. That's referring to IPOB. Yeah. It is a crime, but it's not a crime in Nigeria to be associated with bandits who think government officials going to their wedding, taking selfie with them. It's not evil to be associated with these people that have gone down the Nigerian military, gone down and, invade Nigerian army bases, cut away with so many armory, destroy the ones they will destroy, set ablaze the one they will set ablaze. Those ones are no crime. But because Nnamdi Kanu is asking for secession, now it's like bring him and let's bushire him. Anyway, guys, I don't know what you make of this. Let me know your thoughts in the comment section below. Please don't forget to subscribe to the channel, turn on the notification bell, and let me also know your thoughts in the comment section below. Thank you.